To talk about her involvement in Vice President Duterte's trial, we have on the show this morning veteran lawyer Lorna Kapunan. Welcome to Morning Matters.
Good morning to you and to all our viewers and listeners in Morning Matters.
Okay, attorney, in one of our sister programs, sa totoo lang, you clarified that you are not an official private prosecutor yet. So what is your role right now?
Well, there are many of us legal experts who have assisted. Uh, we have been consulted by lawyers of the House, and we have given freely and voluntarily our legal advice. So there is no official pronouncement as to who will be the private prosecutors assisting the public prosecutors, but that will come in due time. There is a wealth of volunteers who are willing to assist, because this this should be the trial of the century, um, where there is so much gross injustice being done to the people. Lawyers like me should stand up for justice, and as I have said before, we should be on the right side of history.
Provided a trial does happen. A motion to dismiss was submitted by the Vice President's defense panel under an ad cautelam, or a conditional or cautious reply. What does it mean exactly when these two are bundled together? Yung ad cautelam and yung motion to dismiss.
The motion ad cautelam, the answer ad cautelam, what it means is it is with caution. What is happening here is that VP Sara does not want to submit to the jurisdiction of the impeachment court. And that's why, although she has been required to file an answer, she did file an answer ad cautelam, but ang laman ng answer puro grounds for dismissal of the impeachment case. No? So parang it is a motion to dismiss in disguise as an answer. And she is asking for hearing on the affirmative defenses. Sa affirmative defenses niya, there are no new arguments. They're rehashed arguments. Yung issue ng one-year ban, yung issue ng crossover, yung issue ng hindi namang continuing body and Senate, and many other legal issues. And that's why we lawyers have stepped in to give legal advice upon consultation by the House lawyers.
How do you expect the Senate impeachment court to tackle this ad cautelam, because the spokesperson has said that this will be the first on the agenda, when the points raised by the Vice President are actually already before the Supreme Court? So paano kaya yung usapin na yun? Magtatagal po ba yun, or could it be resolved in one sitting?
No, we precisely we do not see where the Senate impeachment court, the Senate president is coming from, because a hearing on a motion to dismiss is not a trial. Ang operative word sa rules of the Senate impeachment court and in the Constitution is to try and decide. And decide would mean a full-blown hearing on the evidence. In the order of trial, unang-unang magpe-present ang prosecution to present its evidence. After that, then it will be the defense. Now, there's due process there because the prosecution's witnesses and the documentary evidence can be subject of cross-examination questions and clarificatory questions by the defense of VP Sara and her team. So when it comes to how should the motion to dismiss be treated, then VP Sara should present it when it is her time to present evidence, because sa pagbasa natin ng kanyang answer ad cautelam, walang evidence doon. Despite the Vice President's public announcement that she is willing to go to trial and to present a bloodbath of evidence. But the answer is this. The motion to dismiss betrays her lack of candor, because wala namang sinabing ebidensya sa answer ad cautelam nor sa motion to dismiss. So, where is the evidence that she promised? In fact, lahat na ng allegations sa articles of impeachment, dininay niya. Ang inadmit lang niya yung personal circumstances niya. No? her name, her address, and her position as vice president. No? I've said before, parang she should deny now that she's vice president because she does not act as if she's vice president of the republic. She's going around. She's gone 4 times in a month. She's gone abroad, and her mission is to destroy the stability of the administration, to destroy the trust of the people in the justice system. Is that what a vice president should do? That's not her job description, unless she already deems herself as the designated survivor, which she has claimed.
Uh, you also mentioned the Vice President Defense Panel appealing for a hearing on affirmative defense. Ano po ibig sabihin nun? Kasi pag ginugal niyo po yung ibig sabihin nun, it would negate the plaintiff's claim even if the defendant's actions are admitted or proven. The defenses are presented in the defendant's answer to the initial complaint. Parang this is tackled especially if they are grounds for dismissal. Kumbaga parang tama po ba yung pagkakaintindi ko na this is the attempt to nullify the whole thing in the first place kahit na guilty o hindi guilty yung defendant?
Ang
And is that
sinasabi
legal?
hearing on the affirmative defenses precisely parang continuation ito ng ginawa ng impeachment court nung 19th Congress, no. Pinagdebatihan yung motion to yung dismissal ng impeachment complaint by resolution initiated by Senator Judge Bato. When that didn't fly, nag-amendment. Yung amendment hindi rin napasa. So, ang nangyari dyan, it got whittled down to a resolution of the Senate Impeachment Court requiring 2 things from the House. No? Sa order nila, sabi nila, without dismissing or terminating the impeachment case, it ordered the House, number 1, to certify that all the requirements of the Constitution and the rules on the 1-year ban rule has been complied with. And secondly, that the 20th Congress, which started yesterday, should certify that it will continue with the impeachment complaint. No? So, ang mangyayari dito, ang pino-foresee natin is it will follow the same mode or the same strategy to delay hearing, trial and hearing and presentation of evidence forthwith because pag hearing on the affirmative defenses, uunahin nila, sasabihin nila meron kaming prejudicial issue dito, which is the issue of jurisdiction. So kung they have the required number of votes, yun ang uunahin. Again, tatagal ang discussion dyan. Ano? There will be all sorts of opinions being weighed in. So, madidelay na naman ang trial. And the danger there is if there is enough votes. Kasi sa impeachment case, 2/3 vote ang kailangan to convict or to acquit. Pag mere motion yan, if it is a motion presented to the impeachment court, hindi kailangan ng 2/3. Kailangan lang ang 1/2 plus 1. So, majority vote yun. And by a majority vote, if that is granted by the impeachment court, the dismissal on the grounds of jurisdiction or pendency of the case in the Supreme Court, then it would have achieved its objective of not presenting any evidence in a full-blown trial. We think that that is contrary to the rules of the Senate and contrary to the Constitution. Ang dismissal ng complaint or articles of impeachment even before trial has started.
Well, if this reaches a dismissal, Attorney Bukoy has already said that it would probably lead to a constitutional crisis if this is a petition for certiorari with mandamus is submitted to the Supreme Court. What if the Senate does not follow a Supreme Court order? What's left to do?
No, the Senate, we have 3 branches of government. The judiciary, the legislative, and the executive. And precisely, there is separation of powers to serve as check and balance. Now, when the Constitution says that it is the Senate which is the sole judge in an impeachment court. The Supreme Court cannot intervene. The Supreme Court cannot say, no, you cannot try the impeachment case. The only time that the Supreme Court can intervene under the Senate impeachment rules and under the Constitution is under what we call Rule 65 certiorari, when there is grave abuse of discretion. Pag wala namang grave abuse of discretion ng Senate acting as an impeachment court, hindi naman pwedeng i-dismiss outright or i-grant ng Supreme Court because that will be intruding into the exclusive power of the Senate impeachment court to try and decide cases. It would be as if the Supreme Court decided, substituted the sole authority of the impeachment court. That should not happen, and knowing that we do have a rule of law, it will not happen that a constitutional crisis will result because we are a country that follows the rule of law. I am of the belief that the Supreme Court will not interfere and will not substitute its own judgment for the judgment of the impeachment court.
Okay. Finally, you've seen the evidence, am I correct, that the prosecution team has?
Yes, because it is the articles of impeachment tsaka yung mga annexes there, which is evidence, no? Evidentially, is in the Senate website, no? Senate impeachment website. Also, we have seen almost daily the evidence presented in the House, in aid of legislation. Nakabigat ng evidence that how inquiry on confidential funds, the inquiry on extrajudicial killings, the inquiry on the hiring of an assassin and threats against the president, the first lady, and the speaker, the inquiry on aliases and malversation of funds, on bribery, on acts of sedition. All of these have been presented on live TV, and we have assessed that evidence, and it really is very strong. Apart from blanket denial by the Vice President in her answer, motion to dismiss, she has presented zero evidence. So, in the balancing of evidence, I think if the senator judges exercise their political neutrality and are faithful to their oath to follow the Constitution and the applicable rules on impeachment, then I have no doubt that there will be a clear road to conviction.
I guess the question is there anything that we haven't seen yet? Kasi nabanggit niyo po na lahat po ay na-present na sa live TV.
Yes, well, I think that is why doon siguro natatakot ang Vice President. Because pag trial na yan, all the modes of discovery are available. Ano yung modes of discovery? Pwede magpasabina. You can subpoena her bank accounts, no? Because her salary does not reflect her bank accounts. There is a deliberate omission of how much money she has in the bank. That can be subpoenaed. They cannot hide under the bank secrecy laws because klaro sa batas na pag impeachment case yan, and it is an impeachment court that orders the production of documents, subpoena testificando and subpoena to produce documents, lalabas yan yung bank records ng Vice President acting as such, and also when she was mayor of Davao City, and also when she was DepEd Secretary. That ayaw nilang palabas yan. Lalabas yan in a trial. The public prosecutors can also subpoena the names, the real names of these alleged recipients of confidential funds. No? So yung mga listahan yung sinertify ng Statistics Office na wala namang existing birth records yung mga nasa listahan. Because under the COA rules and the circulars, it is imperative that any government agency, and that includes the Vice President's office and the DepEd, should have the names of real people,
Correct.
real recipients of real money in a vault. Pwedeng
Yes.
isabit. Maraming pwedeng isabina yung mga seditious pronouncements niya. Yung position niya on the West Philippine Sea, no? That's seditious. When she says, even with her hand gesture, that she's going to decapitate the president, that's seditious. And the fact she
Okay.
admitted publicly in her own interview, her own live interview, that
Okay.
she had already hired an assassin. Pwedeng isabina yan
Tama
lahat.
po. Oo. Attorney, it seems that there is a long road ahead, and we are excited for the prospect of a trial and to see all of that. But I think there needs to be one thing hurdled first, which is yun nga yung ad cautelam ng Vice President. In the meantime, maraming salamat po, veteran lawyer Lorna Kapunan, joining us today on Morning Matters. Maraming salamat.